Hello everyone, welcome to ProdEgyIAS. My name is Khushboo. I guess you people might be knowing me. So I welcome all of you in this, the very first class of mine over this channel. And here I have taken a very important topic, which was a buzzword throughout the year last year and even in this year also, in the starting itself. So it is going to be really very important topic, and it was and it is very important topic. So as I told you that it was a really very buzzword throughout 2023. So you might expect a few questions from this particular topic, either in the prelims or that of the mains also. So prelims are around the corner. So this is the reason why I have taken this particular topic in this class. So before proceeding ahead, just let me tell you that what is going to be the schedule over here, right? So I will be taking total 4 classes, right? So just now I told you as that prelims are around the corner. So my classes are going to be surrounding that itself, keeping focus on the prelims itself, right? So the 3 classes, when it comes to the first 3 classes, this will be completely focused. This will be completely focusing on prelims. Okay, so the whatever the topics or the MCQs or the current affairs, whatever I will be taking, those will be completely focused on the prelims. Okay, so I mean to say that specifically prelims specific topics will be there, just like this topic, that is the governor, right? And there will be one class, the last, which I will be taking every Saturday. So that will be the weekly current affairs. Okay, so this is going to be the revision of the complete week current affairs, wherein whatever the important topics were, I will be taking those, right? So this is how the complete arrangement of my 4 classes look over here on this channel. Right. So let's get started without much ado with this topic, that is the governor. Right. But before that, information, and the information is that GS Genius 50. This is the complete GS Foundation course, which will be starting from 24th of June 2024. So if you are planning to appear in 25, then please do join this. Why? And there are definitely a lot many special features which will be provided, and for that you can definitely contact on the numbers which I will be showing you just now. This is the GS Genius 50. So only 50 students will be taking in this particular foundation batch, so that we can keep a track on the progress of all the students. Next, as I told you, the number from where you can get the details, so that is the number. Apart from that, pub ad foundation course for the 25-26 will also be there, and it is going to be started from 28th of June 2024. So if you are interested to have this particular subject as optional subject, so please do join this thing, because this is being taken by the Ashutosh Pandey sir, who is really very famous for bad subject. Right. So let's get started with this topic. So here what I was talking about, that the governor was a complete buzzword throughout the year. What was the reason behind that? There were multiple reasons. And the reason was the kind of conflict which was actually happening between the chief minister, the government basically of some of the states like that of Tamil Nadu and Punjab, with the respective governors, right? So there was a kind of conflict which was going on between both of these, the governors and the party, the party which was ruling, or you can say the government over there on those particular state. So definitely this governor, the powers of governor comes into the role, that what are definite things, what are the things which governor can do on his own. I mean to say that the kind of things on which he has some discretionary powers. He is actually having some discretionary powers, right? So what are those things and what are not? Where he cannot take those kind of the decisions and all. So I hope that all of you as of now have completed your polity as GS, right? So definitely you people must be knowing what are the powers and what are not there enshrined on the governors, right? So here we are going to talk about the governor and the state government overall, right? So this is the reason And this is the reason, basically, the kind of conflict which was going on between both of these. So we need to talk about this thing because this has even reached the Supreme Court also, right? Chalo. So let's see the historical background with this governor thing. So since 1858 itself, when India was under the British crown, 1858, India was under the British crown. The governor thing came that period itself, right? So provincial governors were the agents of the crown. Okay, the crown, the Britishers, the monarch over there, right? So provincial governors were here in India who were the agents of the crown. This is the historical background which we are doing right now, who functioned under supervision of the Governor General, right? So there were provincial governors, but they were actually the agents of the crown. They were working under the supervision of the Governor General. So as all of you must have covered your history and polity, so you can understand that what is this Governor General and that of the crown, right? I'm not getting into the depth of that. So later on, with the Act of 1935, the governor was now to act in accordance with the advice of Minister of Provinces legislature. So here this particular act becomes really very important. With the 1935 act, what actually happened? The governor was now supposed to act according to the ministers of the provinces legislature. So whatever the ministers will be guiding, the way they will be saying that you are supposed to do this or that, so the governors were supposed to act according to that itself. But there were some special responsibilities and discretionary power which were given to the governors, right? Now when we gained the independence, when we got the independence, when the provisional constitution of 1947 was adopted, from 1935, the post of governor was also retained, right? After the independence also the same thing retained. Okay. And now under the parliamentary and cabinet systems of the governance adopted by India, the governor was envisaged to be the constitutional head of the state, right? So the governor here became the constitutional head of the state, right? Now you have to write in the comment section that who is the head of the country, right? Constitutional head of the country. Now, how is the governor actually being appointed? Who is the one who appoints the governor? The specific question is over here. Now, when it comes to the constitution article here, see, in the last over here itself, we got to know that constitutional head of the state. So it means that in the constitution itself, it has been mentioned. Right. So Article 153 of the Constitution over here, it says that there shall be a governor for each state. So it has mentioned there in Article 153 that every state in our country is going to have, and it is supposed to have, the governor. Now the next day is the Article 155. It says that the governor of a state shall be appointed by the president. So who is actually going to appoint the governor? So that is the president. Okay, there might be some question wherein they can actually, statement based question, they can ask you that the chief minister, the governor is supposed to be appointed by the chief minister of the state. Okay, so don't take that as the correct one. So it is appointed, this particular person, the governor, is supposed to be appointed by the president. Okay. Now, what are the reasons for adopting this kind of appointment when it comes to the governor? See, when it comes to the post, the post of the governor, it is not as such as you can, if you compare it with that of the presidential system over there in the America, right? So if we conducted the governor's the election, the direct election for the governor, it would actually create some kind of conflict. Definitely it is going to create conflict between the governor and that of the chief minister, right? So in order to avoid that, which is completely unnecessary, and our system is of that of the parliamentary system, so definitely we don't at all require this direct election of the governor. So this is the reason why we have actually avoided this thing, right? And it is going to be quite expensive also. We don't need it And apart from that, it is going to be really very expensive as well. So the direct election of the governor is incompatible with that of the parliamentary system, which is established over there in our states. And the mode of direct election is more likely to create the conflicts between the governor and that of the chief minister. Now, when it comes to the dismissal of the governor, suppose that we need to dismiss the governor is not working fine as the kind of duties we were expecting, and the governor is supposed to act. The person is actually not acting. So there is Article 156 over there in our Constitution, and it states that the governor holds office at the pleasure of the president. And here the president acts on the advice of the Council of Ministers. All of us are aware of this thing, that the president is actually not working on his will, right? So the president actually acts according to the advice of the Council of Ministers. And here the Council of Ministers means that of the central government has the power to appoint and that of dismiss the governor. So ultimate power is actually with that of the central government. Okay, so many a times you must have also heard this thing, that the central government, these governors are actually the agents of the central governments. Many a times you people must have heard about this thing, definitely, right? If I'm not wrong. Okay, so the governor does not have a fixed term of office or that of the security of the tenure. So there is no security that once you have acquired that chair, you are, if I have to say, like आप विराजमान हो गए हो उस चेयर पे, तो इसका मतलब ये नहीं है कि आपको हटाया नहीं जा सकता है. Okay, so it means that there is no security when it comes to the tenure of the term of the governor, right? And he or she can be removed at the discretion of the central government. Okay, and as seen in the instances of the mass changing of governors, and all of you must have also seen that whenever a new party comes in the central government, and forms this the government over there in the center, they keep on switching. They basically switch the governors, just like in the state, at the state level. Whenever new party actually forms the government, after that what they do, they keep on transferring the IAS officers, or you can say the IPS officers, from one to different place, right? So the same kind of things happens when it comes to the governors also. There is nothing new in this thing, and there is nothing to be hide, in order to hide also. Next is the constitutional provisions and the judicial interpretation. Okay, what are the provisions related to this thing and the judicial interpretations related to this thing? So Article 154, obviously our Constitution, it states that the executive power of the state shall be vested in the governor and shall be exercised by him either directly or through the officers subordinate to him in accordance with the Constitution. Okay, there is nothing to be explained. This is simple, right? It says that it shall be exercised by him either directly or through the officers. It is going to be exercised by him only, but through the directly or through officers subordinate to him in accordance to the Constitution. Right. Now it comes next is the Article 163. Over here, the governor shall exercise his functions with the aid and advice of the Council of Ministers, except for the functions which require his discretion. So there are certain things wherein the discretion of the governor is allowed, but most of the time the governor is supposed to act according to the Council of Ministers, okay, of that of the state, because governor is at the state level. Now Article 163 clause 2, it states that if any question arises whether any matter is or not a matter as respects which the governor is by or under this Constitution required to act in his discretion, the decision of the governor in his discretion shall be final. Okay, so whenever he is supposed to act on his discretion, okay, he is not under any kind of pressure, right? Nothing can pressurize him. If the constitution has given this kind of power that you have this discretion, just like if I have to give an example, then there is an example of presidential, क्या कहते हैं उसको, राष्ट्रपति शासन लगा देना, तो ये काम कौन करवाता है? So that is being actually done by the governor. Okay, so here this is actually on the discretion of the governor. Here the council of ministers actually don't advise the governor that okay bhai अब राष्ट्रपति शासन लगा दीजिए आप. Okay, so that is actually not being done by that is actually not being advised by the council of ministers. Over here the governor is taking this particular decision on his discretion itself, and he is not under any kind of pressure. If he sees that there is anarchy and the state government is not capable enough in order to handle that, or that of the state government is actually not having the majority, so in that particular case the governor can request the president to do this thing. Okay, so this is what you can take it as the example of Article 163 clause 2. Okay, all these articles are very important. Now there comes one constitutional amendment, that is the 42nd constitutional amendment of 1976. It made the ministerial advice binding on the president, but no such provision has made for that of the governor. It has actually said that the ministerial advice, whatever the advice will be given by the council of ministers to that of the president, then that is the binding on the president. But the same thing does not apply to that of the governor. Same thing doesn't apply. So in this particular case, the governor is actually having more of the power as compared to that of the president. Right? Okay. Here you can see the powers and functions of the governor. Right. So whenever it comes to the money bills, all of you, the powers, or if you say the powers and the functions of the governor and the president are quite similar. Okay, quite similar. So when it comes to the money bills in the Lok Sabha, the money bill are actually being introduced in the Lok Sabha after taking the permission of that of the president itself. The same kind of thing is the prior recommendation of the president. The same kind of thing is actually being done over here at the state level also. Okay, no demand for a grant can be made except on his recommendation. If he recommends, then only the demand for the grant can be done. All the executive actions of the government of a state are formally taken in his or her name. And this is the fact. The same kind of thing happens with that of the president also. So at the country level, so whenever any kind of executive action is supposed to be taken by the central government, it is taken on the name of the president. Okay, the same thing applies over here at the state level also, but here instead of president, on the name of the governor is actually being taken. All executive actions of the government of a state are formally taken in his name itself. Okay, apart from that, he can summon or prorogue the state legislature, right, and dissolve the state legislative assembly as well. Apart from that, he can address the state legislature at the commencement of the first session after each general election, right? So the same kind of thing happens over there in the Lok Sabha also. The president also does the same kind of thing itself. He is consulted by the president while appointing the judges of the concerned state high court. The governor is here he means that of the governor is actually being consulted that whether we should appoint this person as the judge of that particular state. The Kerala High Court or Allahabad High Court or whatever High Court. Okay, he makes appointments or postings or promotions of the district judges in the consultation with that of the High Court. He is the one who does this thing with that of the judges of the district judges. Right? Now, the provisions regarding bills. So here comes the Article 200. Right. So the assent of the governor is necessary for a bill to become a law. Now, in this particular regard, the governor has been given some of the powers, right? Here you can see when it comes to the giving assent to the bill. Suppose if the governor has given assent to the bill, then that bill will actually become the law. If he withhold his assent, he doesn't sign. Assent means he is actually not signing. Then the bill actually fails to become the law. If he returns the bill for the reconsideration of the legislature, if he does this thing, then the state is supposed to do that. If the state legislature, okay, so it has been returned back to the state legislature. Now what happens if the state legislature is actually doing some kind of changes or not, whatever, and the bill is actually being passed all over again and given to the governor. Now at this particular time, the governor has to give assent to the reenacted bill. Now here the obligation is actually there on the governor. If the same bill has been passed with or without any kind of change, right? The constitution actually does not lay down any time limit within which the governor is required to return the bill for the reconsideration. Even if it is actually saying that of the as soon as possible, because there is no definition that how soon. Is it 1 month, 6 months, 1 year, 10 years, how many years? And this is actually the bone of contention over here, because many a times the governors, they basically don't take any kind of action. They are actually not taking any kind of action, and at that particular time, this is something which becomes really very problematic for the state legislature, the state government, you can say, right? And this is the kind of thing which is actually happening also, right? So the governor is actually not taking any kind of action. Bhai, take some action. Bhai, isko return hi kar do at least. Okay, return nahi karna, usko assent mat do, I'm not signing. Take some decision. No decision is actually being taken. So there are certain important things which the state government is actually not able to do just because the governor has not taken any kind of decision on that particular bill. Okay, so this is also a kind of problem over here. Next is reserve the bill for the consideration of the president. So this is the kind of power which has been given to the governor, that if they think that if the person actually think that here I need to consult with that of the president. So here he or she can keep the bill for the consideration of the president. So president may direct the governor to return the bill to state legislature with his or her message, and such bill, if reenacted by the state legislature with or without amendment, is presented again to the president. Okay, it can be actually done. President can either give his or her assent or withhold the assent. It completely depends on the president, and president is actually not under any kind of pressure over here, right? So if the bill is actually being given return, then it can be the kind of changes whatever they are expecting, that can be done, or without any kind of changes also it can be presented again, right? And then it will be presented again to that of the president. Now, what are the recent judgments which have actually came over here related to the governor? So here, when it comes to the state of Punjab, here the Supreme Court has observed that the governor has only 3 options as per Article 200. Either grant the assent, okay, withholding assent or referring to the president. This is the second one. Third is that after exercising any of these options, he or she cannot then exercise another option. These are the three things which has been these options which has been observed by the Supreme Court. Either grant the assent, sign it, or withhold the assent or refer to that of the president. And the third one is after exercising any of these options, he or she cannot then exercise any other option. Either you are doing this or this. Right? After this, you are not left with any kind of option. Okay, so this is what has been said this thing. And here, you actually cannot keep the bill for indefinite period. You have to have taken some kind of action. Okay, no such bill cannot be kept with the governor indefinitely, which is completely wrong. Now there is Vice Chancellor case of 2023. Here Supreme Court underlined that the governors acting in their statutory capacity as University Chancellor are not bound by the aid and advice of the Council of Ministers, because he is actually working as the Vice Chancellor. University Chancellor is working as that person. Okay, so at that particular time, the Council of Ministers is not actually having any kind of power in order to घुमाओ governor. भाई तुम ऐसे करो या फिर वैसे करो. That cannot be done. Next is Tamil Nadu governor case of 2023. Over here, the Supreme Court actually stated that the governor cannot refer the bills to the president after the assembly has reenacted the bills for following the governor's declaration without withholding the assent. Okay, so here the Supreme Court actually has stated this thing, that once the bill has been reenacted, right, the following the governor's declaration of the withholding the assent, after the assembly has reenacted the bills following the governor's declaration of the withholding the assent over here, right? So these are some kind of the decisions which has been taken by the Supreme Court. Now when it comes to the kind of issue between the state government and the governor, this is something which is not new. This has been there in our system since really very long time. So every when and now we had some kind of commissions for the kind of recommendation that how we can actually work better, right? So there was a commission, Sarkari Commission. All of you must be knowing about this thing. So it pointed out that the role of governor is to see that a government is formed and not to try to form a government. Okay, so government is there, the governor is there just to be, okay, the government has been formed, okay, done, my work is done. After that, you don't have any kind of thing that, no, I'm here to form the government. I want this party to make the government, not you. You are not there. You are actually not having that kind of power to do that, right? Whoever is going to have the majority, that party is eligible enough to actually get in order to form the government over here, either by coalition or on their own. You just keep an eye that yes, these are the one who are actually having the majority, form the government. That's it. Okay. Governor should be appointed in consultation with the chief minister of the state. This is the kind of recommendation which was given by the Sarkari Commission. Before appointing the governor, please consult with the chief minister of that particular state and the vice president of India and the speaker of the Lok Sabha. Apart from that, his tenure of office must be guaranteed and should not be disturbed. As I told you earlier that in our constitution, there is no security when it comes to the tenure of the governor. Okay, but here the recommendation was it must be guaranteed and should not be disturbed except for extremely compelling reasons. If there are certain reasons, भाई blunder करती हैं, अब तो हटाना पड़ेगा. Okay, अगर वैसा है, then definitely, otherwise no. And if any action is to be taken against him, he must be given a reasonable opportunity for showing the cause against the grounds on which he is sought to be removed. The person should be informed and the person must be given time, the opportunity in order to prove himself that no, I was not wrong. Okay, so that is there. Next is the Panchi Commission. This is also very important commission, Sarkari Commission and Panchi Commission. The governor here, it said that the recommendations, governor should take a decision with respect to a bill presented for his or her assent within a period of 6 months. Okay, so the time was actually fixed that within 6 months, the decision has to be taken whatever you want to do. And the governors are expected to be independent and to act in manner devoid of any political consideration. Why this thing has been mentioned over here? Because just a few minutes back, I told you many a time this is actually being considered that the governors are actually the agents of the central government. And this is something, after seeing a lot many things throughout the history of our politics, then you can say very easily, you can say that, you can see that, you can say that yes, many a times these governors basically act as the agents of the central government, right? So this is something which is not new, right? So here it is being said that the governor is supposed to act independently. They are not supposed to be under pressure of any, okay, anyone, any political consideration. Okay, once you are governor, you are supposed to act independent. You are not supposed to act in the favor of the state government or either of that of the central government, right? The governor should have a fixed term of 5 years, and removal should be through a resolution passed by that of the state legislature. There was also one commission, that is the Venkatachalya Commission. Over here, the recommendation was that the governor should make use of the advice of the Council of Ministers in the day-to-day administration of the state. Okay, even in the day-to-day kind of thing also, the governor is supposed to take the advice of the Council of Ministers. Then there is one report, that is the second ARC report. This is also very important report. All of you must have read this thing. Okay, so here it states that the governor is neither a decorative emblem or nor a glorified cipher. Okay, so this is something which has been said. Now, when it comes to the powers of the governor, it is quite limited, but he has been enshrined with really very important work, very important powers, very important constitutional role to play in the governance of the state and in strengthening the federalism. So this is what has been mentioned for the governors in the second ARC report. Okay. Now, here we come to an end to our governor topic. Most of the things, most of the things we have covered over here. Now let's see the PYQ, which was based on the governor itself, right? The first question is, no criminal proceeding shall be instituted against the governor of a state in any court during his term of the office. During his term of the office. This is the very first statement. Second statement says, the emoluments and the allowances of the governor of a state shall not be diminished during his term of the office. Now you have to look into this thing and find out that which of these statements are correct. Note that this is the PYQ. Okay, previously it has been asked over there. Here the answer to this question is C, both the statements, right? The correct one, it was asked, both the statements are correct over here. So no criminal action is supposed to be taken whatsoever instituted or continued against the president or that of the governor of the state. No action is supposed to be taken. So obviously the first statement is correct, and this is according to the Article 361. Okay, so please do remember this thing. Now, according to the Article 158, the governor shall not be a member of either house of the parliament or house of the state legislature. And why this is actually being done? Because this is actually expected that the governor is actually supposed to work independently, because this is really very important. The governor is supposed to be not, the governor is not supposed to be inclined either towards that of the state government or that of the central government. Okay, the person is supposed to be really very neutral. Okay, this central madhyam part वो फॉलो करना होना चाहिए. And अगर if a member of either house of the parliament or of a house, then before becoming the governor, that person is supposed to resign. Okay, so this is related to Article 158, and governor shall not hold any other office of the profit. This is also actually being expected from the governor, right? Sure. So this is it related to the class, related to today's class. I hope that you people enjoyed. Do not forget to subscribe the channel. Do like and share also, and do write in the comment section that how did you like the class. So see you in the next video. Bye bye, take care and have a great time. Jai Hind.